Hi, I'm Brenda Wall. I'm a mediator. I work in the Shenandoah Valley in Virginia and West Virginia, and I'm excited to be bringing this video to you today to help you in deciding what you might like to do with regard to your divorce or custody issues. The short video that you're going to be watching now pertains to spousal support and child support in Virginia, and hopefully will help answer some of your questions that you might have about child support and spousal support. A reminder that there is no attorney-client privilege. I'm not giving you any legal advice. This is all just information, and the information is only about Virginia. So if you live in any other state other than Virginia, this information is of no use to you. Every single state has different laws, and you cannot rely on what's happening in Virginia in any other state. So we're going to talk about support, spousal support and child support. And we'll begin with spousal support, which is sometimes also referred to as alimony. There are kind of three ways that we see payments being made. Sometimes the payments are made for a defined period of time, such as a certain payment for 10 years. Sometimes it's just permanent support and it doesn't stop until the court orders it stopped. And sometimes the entire support amount is paid in lump sum. You'll see that sometimes, especially when the parties are figuring out equitable distribution and they want to just go ahead and deal with the spousal support as a lump sum amount. So another type of support that you may get is pendente lege support. That just means temporary support. So sometimes when parties are separated and they go to court, the court might order temporary support. Sometimes when I'm doing mediation, parties often agree to a temporary support amount. Now in Virginia, there are guidelines as to what that amount should be for temporary support. That has never been intended to be used as a permanent way to establish support. It's just a guideline for temporary support. Generally speaking, anytime we're talking about spousal support in Virginia, these are the factors that the court generally looks at in deciding whether or not to award spousal support. What I usually see spousal support ordered in is cases where the parties have been married a long time and one party gave up income earning capacity to be able to take care of the family. So if one person stayed home to take care of the kids and the other one went to school and got an advanced degree and is earning a lot of money, that would be a suitable case for spousal support. Typically in very short marriages or when the parties have similar income, spousal support is not ordered. If it's in your agreement that spousal support can be subject to modification, it is possible that it can be modified. Back up here. That modification is going to require court action. So once you've got an order requiring spousal support, if you want it modified, typically, unless you say right in the agreement that it's only for 10 years, if you say it's permanent support subject for modification, then you would have to go back to court and it can be modified. Typically, modification would take place in a change of circumstances, such as when somebody's retired or somebody becomes disabled, or maybe the lower earning spouse was able to increase their income earning capacity. So they went up and tried to modify the spousal support. So things to remember about spousal support is that it can be entered for a period of years or permanent, or can be paid in one lump sum. And there's a number of factors that the court looks at to decide whether or not spousal support is appropriate. Let's talk a little bit about child support. Child support is based on a number of things. One of the most important one is gross income. And so Virginia uses a set of guidelines and you plug numbers in and what they decided is the fair way to do it. So those numbers that get plugged into the formula are gross income. It does not include net, but your gross income. It includes whether or not support is being paid for other children. If a person's been married previously, then that would come out of the formula. Also, the person paying for daycare expenses and health insurance receives credit under the guidelines for setting up child support. There's also two separate guidelines for establishing child support. One for when the parents have shared custody or joint custody, and one when there's sole custody. So it really depends on how many overnights the child is in each house as to which formula applies. Now, can you ever go off the guidelines? Yes. So if the parties say agree, so the guidelines, maybe they come up with a $800 a month for support, but the parties think that there really needs to be 900. Can they do that? Yes, it's just important that their agreement and says what the support amount should be and why they are deviating from that guideline. Just like spousal support, child support can be modified at any time. The party's income changes, that the schedule for when the kids are back and forth changes. Any of those things can require that you go back to court to ask for modification. I do want to remind you that until you go back to court, it is still an order. So if someone loses their job, they need to go to court immediately to modify support. Otherwise, they end up continuing to accrue an arrearage for not having paid child support, even when they didn't have a job. So the modification only occurs when the judge signs the order. So you have to go to court to get child support modified. Any more questions about spousal support, child support? I will offer you a free meeting with me. Just go to brendawall.com and you can sign in and schedule a meeting. That's 15 minutes. You can ask any question you like. I also urge you to watch other videos we have. I have some about child custody, about dividing property, about the process for getting divorced, and about the options, whether to use mediation or litigation. So good luck to you, and I hope this has been useful. Thank you.